David Katz. Hello, sir.
Great to be with you, Mark, Kim.
It is so much fun to talk to you always. A lot going on. I was talking in the first hour. We'll try to kind of move these things along, David, but I was speaking about the fraud trial that was going on in New York and is going on in New York. The Trump kids now are being paraded in. The answer that the two Trump kids who have already testified, the answers they're giving are associated with, I didn't know. This is about the valuations of properties. This is about the fraud associated with those valuations. I wonder if you can speak to just the state of the state on that, and then we'll move on to the situation with trying to remove Trump from the ballot.
Well, it's very interesting. It's a civil case, and that's why the plaintiff, the state of New York, Letitia James's office, can call people like that to the stand. They couldn't do that if it were a criminal case against them. You can't, as the prosecution, call the defendant to the stand. The defendant has the right to take the stand, but the defendant in a criminal case also has the right under the Fifth Amendment to not take the stand and to not have any comment made upon the fact that the defendant didn't take the stand in a criminal case, and no inference of guilt can be drawn. And there's an instruction, and sometimes jurors do it anyway, and you have a jury misconduct issue after that because that's not supposed to happen. This is a civil case, and it's confusing because you hear the word fraud bandied about and these charges, but it's civil fraud, and the other charges are civil. They have quite a consequence that the business license of the Trump organization could be suspended. It looks like it will be suspended. That would bring a receiver in and make it very difficult for Trump and his kids to make decisions. They'd basically be ousted from control over major decisions. So that's what's at play. And so the subpoenas have been given to Trump's two kids and to Trump himself. Now, Ivanka Trump is fighting her subpoena. She won in the appeals court that she cannot be a civil defendant in the case because the statute of limitations ran on the civil charges. That's the only reason that she's not in the civil dock along with the rest of them. So they have called both Trump kids to the stand. Now, either one of them could take the Fifth Amendment, even though it's a civil case, if their answers could incriminate them criminally, but that's a bad look. So instead of that, they've plotted ahead with the testimony, basically with Don Jr. saying, I didn't know anything. Yes, I signed all the documents. And of course, in signing them, you're acknowledging that you've read them and understand them. I mean, you cannot, say to the IRS after a phony tax return is filed, well, I didn't know what I was signing. My accountant put some numbers down. I don't know anything. The whole point of signing something, Mark, is that you're endorsing it. And so this is...
But David, I'm going to interrupt, but Kim was making this point last hour when we were talking about this. She said, but, isn't it, Mark, kind of defensible? I mean, sometimes we sign these tax forms. We don't really go over them that carefully. They're done by tax preparers. And I was making the point that, but this is about valuations. That is what the business is, that they value properties, they borrow against it, et cetera. So we said it was a slightly different situation. But is it at all defensible that, hey, man, it's the accountant? I don't know.
Well, just for the average person, it's certainly true for the average person. And you have a lot of these innocent spouse cases where especially the wife, that's the typical situation, still comes in and says, I had no idea what I was signing. My husband, my accountant put this thing in front of me. I just signed my name. And yes, that's often accepted by the IRS to find someone an innocent spouse and to say that spouse doesn't have to pay the piper, doesn't have to deal with the consequences, even though the spouse has signed. And even people who sign things under penalty of perjury, never a good idea, say, I didn't read it. I wasn't knowingly lying because I didn't read it. Now, you're in a whole different situation from the innocent spouse and from the everyday situation that comes up with people. You sign something, you're returning a car, who knows what they're signing. You want to run to make the plane. This is not that situation. Right. When Trump became the president, he was supposed to put everything in a blind trust. Of course, Trump never wanted to play by the rules and the norms, so he didn't put things in a blind trust. The Trump organization was run by three people. Guess who one of them was? Don Jr. has been since 2021 a trustee of the Trump organization, who along with his dad and this Weisselberg are responsible for what it does, for its major decisions. So this is a complete farce. The judge, by the way, who's the juror, he's the one who's going to decide not just the law, but the facts. It's without a jury. He's totally unimpressed with all this nonsense. This idea that, well, the accountants did it. That's what we pay accountants for. It's just common sense. And the higher up you are and the bigger the organization is, really the less defense that you have. You need to know what you're signing. And to the extent that he verified things, Mark, like that his dad's place was worth $300 million because it was 3 times as large as it is, that's not an opinion. A measurement of space is not an opinion. And he obviously connived in that. He signed those things. And again, just to relate it to, let's say, a tax return. Yes, you may not understand all the schedules, but if you made, I don't know, let's say $100,000, okay, and your accountant puts down you made $10,000, you're going to notice that. If you haven't paid any tax after you've had a great year and there's no tax due at the end of the year, you're going to notice this. And these things by Donald Jr. are egregious. Apparently, while he was running around giving speeches and playing celebrity, which is sort of his defense, that his brother, although his brother wasn't the trustee, he, Don Jr., was the trustee, really talk to my brother. He's the one who was really running things. He's on the stand next or right now, and I'm sure he's going to say the same thing. He had no idea what was going on. That's what we pay the accountants for. None of this is going to work. I'm a criminal defense attorney now. Everybody in my tax cases, half the cases that are filed in federal court that aren't immigration cases are someone signed a piece of paper that turns out to be false, and it's a false statement case. And if everybody could say, I had no idea what I was signing, things, number one, they would totally break down. And when you sign these things under penalty of perjury or certification, okay, look at what you're signing, especially if it's an important matter about your finances, and especially if you're in charge of the company or the organization. So this defense is no defense.
Quickly, and then I will get to the Colorado case, removing or trying to remove Trump from the ballot. The pushing of the documents case now, in that, the Trump judge in Florida who ends up with this case is delaying. I mean, the Trump trial down there is scheduled for May of next year, and now she wants to push it even farther down the road, which helps. That's essentially what the Trump people want. That document case, which seems so open and shut, that may not come to trial for a long, long time, huh, David Katz?
Well, Katsadamas will not even take a point of accurately predicting that one because it was too easy. It was a softball. Everybody presaged and predicted that she was going to kick the can down the road until after the election. And of course, she's already starting to kick the can down the road. First, she says there has to be a SCIF, a place to look at very confidential documents. It can't be in Washington, although no defendant in America probably has as much money and has access to go to Washington all the time to review the documents as Trump. But no, that's too onerous. There has to be a SCIF down in Florida. It sounds like a parody, but now it's so hard to build a SCIF. It takes a while to build a SCIF, to do the certifications. Oh my God, there's all this delay. I could have told her there was going to be this delay if she demanded that Trump have access to a SCIF down there in Fort Pierce, Florida. This all goes back to the original sin of being way too nice that Jack Smith filed the case down in the Southern District of Florida. We talked about this till the cows came home, that he had every right to file this case. There was perfectly proper venue in Washington, D.C., and instead he took a 1 in 3 chance of getting loose cannon. And she's going to be very loose with the deadlines. Now she says there are discovery problems. What she needs to tell Trump is the same thing that I think that the district judge in Washington, D.C. on the conspiracy case there has told Trump's lawyers. Hire twice as many lawyers if you need to. Whatever your problems are, getting certified, getting this, getting that. If you have 6 lawyers, hire a dozen lawyers. If you have 6 lawyers in one case and they're the same 6 lawyers in the other case, no. Don't come and say, oh my goodness, Your Honor, we just had this case in Washington, D.C. in March. How can you expect us to go and try this case in front of you in May? Guess what? Get a different team, get a supplemental team. Both those cases should go. So, yes, she's going to kick that can down the road, and it's an open and shut case against Trump. He is guilty, Guilty, without a doubt. What did OJ used to say? Absolutely 100% not guilty. He is absolutely 100% guilty, Trump down there. But the case won't go to trial before the November 2024 election. And I will not take a point of accurate prediction for that because it was too easy.
Well, I'm laughing also because the whole idea that you need a delay in the court schedule because you're too busy with other court cases because you're that lawless is very funny. Like if you break enough laws and you end up in enough courtrooms, the judge, if friendly, will just go, "Oh my God, yeah, of course you're overwhelmed. Let's take care of this in a few years." You know.
Mark, the judge said, has there ever been a case like this? I think she asked some question like that and people stood around. Michael Avenatti's case was a little bit like this. He got himself in a world of trouble. People said he was being prosecuted too much, that, for instance, taking Stormy Daniels' money and not sharing it with her or not telling her that he got it in his trust account is not generally what the federal government prosecutes. Do you know what I mean?
Sure.
Yet they prosecuted that case. They prosecuted 3 other federal cases against him. He had to juggle. He ended up righteously with a public defender, maybe because he'd blown all the money and should have saved it for a rainy day like getting indicted. But apparently he didn't. He had public defenders. Even so, he had remember, 4 different cases. I think he pled guilty in at least 1 or 2. He tried at least 1 or 2. And so this idea that if you get yourself in this much trouble, you're going to have a busy court schedule. But the thing that makes it so different, 2 things. Number one, there is a strong public interest which overwhelms the private interest. The public interest is in the public knowing before the nomination and before the election whether a jury of his peers found Trump guilty or not guilty. Let them find him not guilty and let him trumpet it to his potential voters. Let them find him guilty if that's what fate's going to be, and let the voters know that. There is a huge public interest in that, which is not just the private interest in having enough time to go through the discovery and stuff like that. And the second thing is he's got all the money in the world. He's a self-proclaimed billionaire. He apparently posted a huge amount of bond in one of these cases. So he has some real walking around money. Then he has the big steal where he got it from his base and supporters. Supposedly they'd be fighting these legal cases. Okay, so go spend millions of dollars if that's what it costs. Get yourself a great team for the Washington case. Get yourself a great team for the Southern Florida case. And guess what? Get ready to go by the dates that the judge set. He
doesn't need a team for the Florida case because he's picked the judge. So he took care of that when he was president. Kim, can I move on to the Colorado case because I'm running so far behind with David? I wanted to ask him about having Trump's name removed. Did you have something? I'm sorry.
No, I was just reading this article about Trump Jr.'s testimony and how everything he says is given more scrutiny because it's a judge that is making the decision, not a jury. And so my question was, what's better for a defense attorney or for the Trumps in this case? Trial by jury or trial by judge?
Let me take a crack at this. First of all, as you know, we talked about this with David Katz. He decided, Trump did, that he didn't, his team, that they wanted a judge. And the reason they decided that, I think, David Katz, please let me know, I'm only auditing the class, that a jury in New York would find him guilty. Why? Because everybody in New York is hip to the fact that Trump is a fraudster and a charlatan, and no one likes Trump. Now, am I wrong, more or less right, David Katz?
Trump managed to lose all the millionaires, Republicans, on the east side of Manhattan. Think about that. He can't even win the super rich. Why? Because he's a fraudster. Even if you like the message, he's the wrong messenger. So yes, people in New York know that. I don't think he wanted a jury, but he should have asked for one. That, I think, was a lawyering mistake. I think he should have asked for one, been denied one, and then it's another appeal issue. Unfortunately or fortunately, good defense lawyers always have a plan B. What about this? What about that? If you don't ask for it, you can't get it. He should have asked for it, been denied it, and had that as an additional appeal issue. Let me talk about Colorado real quick.
Please. Now, this is about removing Trump from the ballot because of the 14th Amendment. Go ahead, please.
Well, I saw David K. Johnston on this on your show, and I thought he was terrific and had a lot of interesting insights about it. And he's persuading me a little bit. I was more skeptical about it. My thought is just that it's such a precedent. If you can do this, you can do this with other people. He's not the only person who some rival or the other party would say, this person who wants to be on the ballot supported an insurrection. Now, I think what helps is a couple of things. Number one, they were in the Capitol. I mean, if you look at the framers of this 14th Amendment back in 1868 or whatever, this was exactly what they had in mind. The Civil War, the insurrectionists, they used the word rebellion. And what's the sort of thing that they would have done? Not have mass rallies in the street that somebody supported and someone would call an insurrection. They would raid the U.S. Capitol, exactly what Trump did. This may be really sui generis. It may be Trump did exactly that. He not only aided and abetted it. He not only encouraged it, ignited it, supported it, but look what it was. It was an actual raid on the capital of the United States where people were killed. So I'm starting to sort of like that aspect of it. But it also occurs to me that even if this won, it would have to win in a state that Trump was likely to win.
That was Johnston's point. Yeah.
Yeah, if it's Colorado, and he really were taken off the ballot in Colorado, and the U.S. Supreme Court denied certiorari and didn't take the case, and that was the final judgment, okay, it would be weird in Colorado. It would certainly hurt the other Republicans running that there was sort of no candidate for president like Trump. Trump was the nominee, and yet he's not on the ballot in that state. But even so, Trump was always going to lose Colorado. Trump's always going to lose California. He's going to lose all these other states where he might be kept off the ballot. So you got to get a state that actually is going to rule this way like Colorado might. And that might be Pennsylvania. Pennsylvania is a pretty Democratic state. If you were off the ballot there goes Pennsylvania to the Democrats. Other states like Wisconsin, that's a swing state, pretty Republican state with there's a 4-3 Supreme Court, but that's one's questionable. Georgia is a Republican state. It's hard to imagine that he would win. So each one of those trials might be kind of held on its own, decided on its own, and it might actually be that this is the one insurrection at the U.S. Capitol that really does fit within that definition. And they had an expert witness testify since I last opined on it, who went back and looked at how the expression insurrection and rebellion was used at that time, how scholars wrote about it, and so forth. And this may be the case. And in terms of Trump inciting it, that part, the 14th Amendment, seems pretty straightforward. And the last thing, as to the argument, which a lot of people have made, it seems compelling that, well, this is inconsistent with the First Amendment. That was the First Amendment. The 14th was the 14th Amendment. Later on, the argument goes, they carved out, right, a part of the First Amendment. So you have a right to all of the panoply of First Amendment rights that you can imagine, except that they got limited later on. They got limited later on by you cannot encourage or support an insurrection. So guess what? Any candidate has a right to say anything they want to under the First Amendment, but not that under the later 14th Amendment, right, that carved out something that's not covered by the First Amendment. It was, and it's never been changed. People say, well, there was legislation, they didn't take it seriously, they revoked it later on. But guess what? They didn't change the Constitution. So that is the last word in the U.S. Constitution. The First Amendment's not the last word. This is the last word. Might actually work.
On these cases, is it appealable to the U.S. Supreme Court, or because elections are up to the states, does it stop at a state Supreme Court in this case?
Trump would argue that there is a federal right to run for president unless you're under one of the disqualifications. If you're over the age, you're born in the United States, and there's one other requirement. And he would say this now imposes another requirement, which is not the law. I have a federal right to run for president of the United States. That would, I think, raise a federal question that would go to the U.S. Supreme Court. So it would go from the Colorado Supreme Court. If the Colorado Supreme Court says your name is being kept off the ballot because you encouraged an insurrection, he would say that violates my rights, my federal rights, and he would take that case to the U.S. Supreme Court. The U.S. Supreme Court would not have to take it, but it could get there. That would be the route by which I think it would get there. I still think that they're likely to vote in his favor, 5-4 or 6-3, vote in his favor and undo such a ruling that would keep him off the ballot. And everything's going to be very expedited. All of a sudden, Trump's in a big hurry. All of a sudden, he's got lawyers who have all the time in the world to be in a big hurry. It's just amazing how these things happen.
I've got to wrap up. I wanted to get to a couple of odd cases. David, I wonder if we can start a little earlier next time.
Can we do the odd case real quick, the National Realtors case?
I love that Realtors case. Yeah, give me just a minute on that if you would. So let's set the scene, because this may affect realtor commissions nationwide.
This may affect realtor commissions. This is a class action suit, which is going forward in Kansas City, Missouri, in federal court. The judge has not actually set the injunction yet. When we see the injunction that ends up being issued, that may affect California. It may affect the nation. A lot of people think it's going to affect the nation because when the jury held against the National Association of Realtors, Zillow stock went down 7%. Another stock went down a lot. This involves the Berkshire Hathaway subsidiaries owned by Warren Buffett and other investors. And so it has a huge impact. There actually were 3 defendants in the case. One of them was Remax. Remax paid $55 million to settle. Another real estate company paid over $55 million to settle. And now the jury has come back with a verdict of $1.8 billion against the existing defendants in the case. And there's 2 aspects to it. When you sell a house, normally, you're going to sell a house for $1 million, let's say, and out of that, 6% is the commission. And then there's the other side of the transaction. There's all the buyers that you want to have come look at the $1 million house, right? And so what the listing agent says that out of the 6%, they're going to give 3% to the buyer's agent. First problem is that a lot of times the buyers don't know that. Now, you should think logically that, the agent's getting something. You're not paying him. What's he getting to run around and find you this house? But it's often not disclosed. That's one problem, the non-disclosure. Even if it were disclosed, okay, the problem is that there's something called the MLS, which is the listing service, okay? And to get into this listing service, you have to play ball. If you don't pay the 6%, you don't get into the listing service. Now, people tried to get around that with Remax, lower commission. People tried to get around it by selling the house themselves, right? And nowadays, with the computer, you can certainly publicize the fact that your house is for sale. People should come to you. You could have giveaways. You could do all those kinds of things to save yourself the 6% commission. But anyway, the way that the National Association of Realtors does it, the fact that they don't make the disclosures that they should disclose, the fact that it seems to always have to be 6%. I think in some places, maybe it's as low as 5%. So this class action suit said, you owe us, all these people who sold our houses and who bought houses in Missouri, you owe us a big chunk of that commission back. That's the $1.8 billion to pay that class of people back the supposedly gouged, the excessive commission. Now, I don't know, people can use their common sense about this one and say, well, wait a second, think about it. 10 years ago, you could sell your house and pay the 6%, or you could sell it yourself. A lot of people think, you know what? The good realtor, the guy who really knows what he's doing, the gal who really knows what she's doing, is not going to get me $1 million. They're going to get me $1.1 million. And if they get me $1.1 million, very well worth paying the 6% commission. And if you're the buyer, okay, you think, I want to see everything that's out there. I don't want to go through the computer and just cherry pick, oh, this one, that one, the other one. You want access to the MLS so you can see all at once, well, here are the places in Venice or in Sherman Oaks that I want to buy. So I feel it's a rather complicated economic issue, but it might lead to lower commissions. One last thing, all these other advanced economies do not have that level of commissions. They presented evidence that like Australia, the United Kingdom, the Netherlands pay about 1 or 2% commission on a home sale. All the commissions altogether are 1 or 2%. This 5 or 6% is a problem. And the very last thing, the Department of Justice has been monitoring that case. They actually intervened in that case. I'm not exactly sure what role they played, but it might be a major antitrust case nationwide about how these commissions are set. Maybe they're antitrust violations, whatever. This has a huge impact on the market. As I said, stocks already went down 10% just on the news of what the jury decided, $1.8 billion.
I think it's massive. I'm so glad that you explained it that way. And I think we want to follow up on this because, as you say, it could have a titanic effect on the way, well, real estate is sold. I mean, commercial and residential real estate in this country. So really big. David, we'll be in touch. We'll maybe get you on a few minutes earlier next time so we'll have a little more wiggle room. But I love all the territory you've covered. Thank you so much. Hi, it's Mark, and I thought that was great. Hit the notification bell. You'll know whenever there's a new video being dropped, and please subscribe to our channel to help us save the universe.